Good afternoon. I'm Tara McInnes and I'm a partner at the Burnside Partnership. I'd like to welcome you to the first in our series, Emerging from Lockdown. This video is on wills and estates and presented by Kate Allred. Just to say a few words about the Burnside Partnership first of all. We're a specialist law firm with a team of experts advising on private clients, contentious wills and estates, tax and trusts. This series, Emerging from Lockdown, takes three topics: wills and probates, lasting powers of attorney, contentious wills and estates, and for each reflects on what challenges have lockdown created, what's been learned and what's changed, and how might those lessons and changes be applied as everyone emerges from lockdown, and as we all hope, normality resumes. So I'm going to pass you over to Kate, who will introduce her topic. Thank you.
Thanks, Tara. So my name's Kate Allred, and I'm a senior solicitor in the Burnside Partnership's private client team. Have over 25 years experience, and I've practiced for the last 20 years in Oxford with both local and national law firms. My areas of specialism are wills, estate planning, creating trusts, both pre and post death, complex probates, and also post-death tax planning. So moving on to the next slide, we're looking at COVID and the aftermath and what can we expect going forward in terms of my area of work and what would be relevant to you as potential clients or potential referrers. And really the issues and trends emerging as we come out of lockdown will, I think, be areas where we really need to review what's happened in terms of unexpected deaths, taxes, and wills that might have gone wrong or have actually gone wrong, unfortunately. And there are areas where I think we can help and add value to clients. And there's certainly scope here in terms of post-death planning and looking at rearranging estates, taking into account both inheritance tax and also ensuring that there is reasonable financial provision for beneficiaries who potentially may have suffered financial hardship. So moving on to the next slide. Death, taxes and childbirth. There's never any convenient time for any of them. And that is a quote from the author of Gone with the Wind, Margaret Mitchell, and probably quite appropriate actually for the period that we're coming out of. In terms of the impact of COVID, obviously it's had a huge emotional impact across society in terms of both mental health, but also in terms of clients suffering with grief, dealing with bereavement. And as private client lawyers, obviously this is an area that we have to address. And we're also addressing situations where people are concerned and anxious about the future and their affairs. And so we've had to adapt to deal with that. And we've been getting used to Zoom meetings with clients, which has made us increasingly accessible to them so that they've been able to see us and we've been able to prepare wills for them. We've undertaken home visits with precautions where necessary in order to make sure things are done as they should be. And also we now have online applications for both probates and in fact lasting powers of attorney, which has made it possible to some extent to keep things going, although obviously with the volume of work there have been delays, largely a result of the probate registries and HMRC. And in addition to that, to try and make sure wills are being completed during lockdown, we've had video witnessing on occasion, as well as drive-through wills where we've offered a service to be able to ensure they're executed with 2 witnesses. So we've had to be flexible. Inevitably, however, some of these circumstances can lead to issues with wills, and in particular one area of concern is in the future going to be whether the will can be challenged. And so we do have to make sure that as far as possible the will that has or might have been prepared during lockdown has been checked, there aren't any issues in it. In particular wills that might have been signed at home or where beneficiaries might have been excluded that might have expected an inheritance, we really do need to be careful in those circumstances. So here you can see that one of the ongoing costs of lockdown and COVID has been a dramatic increase in intestate estates. And it's interesting, there was some research carried out by Anglia Research which showed that the number of people dying without wills jumped by 60% across England and Wales between March and May last year in the first lockdown, compared to the same period in 2019. And so it is a concern. And what happens in intestacy? Well, this arises where either there's no will, or there might be an invalid will because it hasn't been signed correctly or properly prepared, or it could be that it's a will that failed to deal with the what-if scenarios. In other words, where beneficiaries may have predeceased and there haven't been appropriate alternative provisions made. And the intestacy rules are still quite outdated. They have been, or they are reviewed, but in some ways they're still quite traditional in approach. And so, for example, cohabitees are still not entitled to any provision under the intestacy rules. So they may be in a situation where they have to make a claim for reasonable financial provision, and with all the associated costs of having to do that, regardless of whether it might be an agreed situation with a family. Another example is spouses who have survived with children. And as from the 6th of February 2020, the legacy to which spouses were entitled was increased from 250,000 to 270,000. And apart from that, they're entitled to half the residuary estate. But the remaining half of the estate would then be held on statutory trusts for their children to inherit at 18. So apart from the inheritance tax issues that might represent, because suddenly you're in a situation where spouse exemption is limited, and so it may well be that there's an inheritance tax charge where children inherit half of residue. Apart from that, then there's the issue of whether those children would be sufficiently responsible. Is that sufficient, reasonable financial provision for the surviving spouse? And really, would you want them to inherit at the age of 18? And so in that situation, one of the solutions available would be to look at post-death arrangements, a deed of variation, but that's only possible with consent. And if you have children inheriting who are under the age of 18, then unfortunately the law doesn't allow them to consent. And as a result, an application to court to vary any trust provision would be necessary. Again, costs and delays, the usual problems associated with that would kick in. So moving on to the next slide, what I've done here is highlighted a recent case. It's a High Court case where basically a poorly drafted will resulted in a husband and wife dying and the estate remaining intestate despite them having wills. So the husband and wife died in 2019 within a few months of each other. Their wills appointed themselves as sole executors and sole beneficiaries. The husband had provided instructions for a new will, but unfortunately his wife had previously died and he died before he could sign the new will. So therefore his estate was intestate. And his brother and sister were intended to benefit solely, but under the intestacy rules, his nephews were also equal beneficiaries, simply because I think there must have been a sibling who had predeceased leaving children, and so the predeceased siblings' share would have passed to his issue. As a result, even though the husband had tried to make deathbed gifts, the court had ruled that those gifts didn't meet the criteria to be valid. And so the decision was that the siblings and nephews inherited. And really the issue there was the fact that will didn't deal with the what-if scenarios. And really a good will should always address that. Examples would be, for example, executors and trustees who might lose capacity, or they might have predeceased, in which case you should always have a substitute appointment. The ultimate scenario is to have a fallback position where a professional is appointed and you know for certain that somebody will be able to step in to deal with the estate. Another example is with minor children. If you're looking at potential scenario where both parents die, you should ensure that guardians are appointed who would be able to make decisions with parental responsibility for those children. And they would be the homemakers, the home providers, and they would need to liaise with the trustees about financial provision for them. But again, you need to make sure that substitute provisions are made just in case anything happens to the appointed guardian, whether it be capacity or them having predeceased. And that then leads on to other problems with wills. So, for example, one issue, which isn't uncommon, can be whether the intention of the testator is clear. So an example of this is where a will makes provision for children, and the usual wording would be to such of my children as may survive me, and if more than one, in equal shares. And it may well be that would be a suitable will for a couple with young children, and they're not really concerned about any further provision, although in reality, some sort of default provision might be sensible. But they haven't updated the will since they originally did that, and there is no provision or further provision in that will. So what happens if at a later date, one child has died, predeceased, leaving children of their own? So Section 33 of the Wills Act steps in usually, or can do, and that provides that where a gift to a child who is predeceased, then unless there's a contrary intention in the will, then the child's issue should inherit. And then you go back to the wording, to such of my children as may survive me, and if more than one, in equal shares. And so that has been held to show a contrary intention, because really that wording says that any surviving children inherit, and only surviving children. But there has been conflicting case law on that point, and so there's no certainty about it. And what you don't want with a death scenario is a situation where there's doubt, conflicting case law, and then the issue of legal costs because of claims through the courts. Other issues that might arise will be where gifts are potentially subject to consents. And consents can only be given where there are no issues of mental capacity. So another common scenario might be where a husband and wife jointly own property, and they want to set up a life interest trust to ensure that following the first death, their children will inherit, but whilst the surviving spouse is alive, they can continue to live in the property or should benefit from any income on trust funds. And if there's enough money or more than enough money, then the trustees can make gifts of any money in that trust in order to save some inheritance tax. But it's not uncommon for those trusts to require the consent of the surviving spouse before making any gifts, and indeed consents to authorise the sale of the property in which they live. And if they lose capacity, they can't give that consent. So really the question is whether or not you've appointed the right people as trustees to be able to deal with that situation. And if so, really, did you want to have a consent provision in the trust? And that's something that has to be checked and addressed really at the time the will is drafted. And then we have unintended tax consequences that might arise. So another technical point, for example, would be the fact that a child under Section 31 of the Trustee Act automatically acquires an interest in income in any trust in a will at the age of 18. And unless that's excluded, it means that an adult child who potentially would have been a beneficiary of the bereaved minor's trust to inherit, for example, at the age of 25, then will acquire an interest at the outset in income. And that has consequences for both inheritance tax and capital gains tax reliefs on when that trust interest vests. So again, really, in a professionally drawn will, those are issues that can be addressed and considered at the time the will instructions are taken. Another issue will be default beneficiaries, which are the long stop, if you like, or the final beneficiaries for disaster scenarios. Other issues, cohabitees, as I've mentioned before, they have no rights or provisions, if you like, on intestacy. Another issue will be reasonable financial provision. So particularly now, in times of hardship, it may be the will hasn't been updated recently, And at the time instructions were given, there was no need to benefit certain members of the family, maybe adult children. Well, their circumstances may well have changed at this stage, particularly after a pandemic. And the difficulty will be with a will that's not flexible. The trustees and the executors won't have any discretion to be able to address that financial provision. And it may well be in that case that the potential beneficiary would have to make a claim and a proceedings as a result at court. So a will that's been drawn up in an inflexible way should really be reviewed. And really, I think it should be checked with the individual whether or not that's the right will for them and their family. And another couple of smaller issues will be, for example, identifying gifts in the will. So I've seen wills in the past, for example, where bequests have been made for specific bank accounts, and those accounts no longer exist at the time of death. And you might think, well, it's all right, the executors can simply pay the equivalent in cash, but they sadly aren't entitled to do that. If the account no longer exists, the gift will fail. And finally, unexpected tax consequences can also mean losing tax relief. So, for example, in a period where house price property values have risen dramatically and nil rate band allowances have remained fixed, there is an issue in terms of the availability of the residence nil rate band allowance. And part of the criteria for claiming that allowance is really ensuring that any estate falls below the £2 million threshold. And it is possible to try and carve out interest through the will in order to try and achieve that result. So then moving on to capacity, this is another area where there might be challenges to a will, which again really is something we can address now when reviewing the wills. So the case mentioned on the slide is the case of Clitheroe, which is a 2021 appeal case. And in that particular case, the lady who wrote a will considered her daughter was a spendthrift and a shopaholic. And as a result, she decided to disinherit her and leave her entire estate to her son. The daughter had argued that her mother suffered an insane delusion as a result of being traumatized by her other daughter's premature death. Meanwhile, the son tried to argue that the appropriate test for considering his mother's capacity to do the will should be a different test to the traditional test of Banks and Goodfellow. And instead, he wanted to argue that in an era where senile dementia is more common, that the Mental Capacity Act test should apply. And that says that a person must be assumed to have capacity unless it's established that they lack it. And they shouldn't be treated as unable to make a decision simply because they make an unwise decision. And that's quite a different test in terms of onus of proof compared to that of the more traditional test of Banks and Goodfellow, where an individual has to show that they would have been capable of understanding the nature and effect of the will, the extent of their property and the extent of moral claims into the will. For now, the case has been adjourned, but really, as it is taking instructions, the onus is really on the will drafter to check capacity at the outset, and if any doubt, to get a medical opinion. The issue has been during lockdown, being able to get that medical opinion, and also taking instructions perhaps more remotely makes it more difficult in terms of really gauging the level of capacity there. And finally on this, another area of concern for wills will be the execution of wills. In other words, have they been signed correctly? And simply inserting an appropriate signature clause called an attestation clause at the end of the will isn't in itself enough really to guarantee this. If the signatories don't follow those rules, then there is a possibility that the will could be challenged. And this happened, in fact, in the case of Professor Robert Whalley. And his original will benefited the British University in Dubai, and that will was dated 2012. And they challenged his 2018 will, which was made in favour of his old friend, Ebrahimi, and his wife. and it was a reasonable size estate worth 1.8 million. Now, the will had been signed by the testator on the 3rd of May, and that was witnessed then on the 4th of May. So you can see that the witnesses weren't necessarily present at the same time on the 3rd of May, which they should have been. Having said that, there was a second attestation clause on the back sheet to the will, and that had been added and signed on the 3rd of May by the witnesses. So there was contradictory evidence there, and so the witnesses were called to give evidence, having already prepared and sworn affidavits agreeing the will was signed 3rd of May. And at the hearing, surprisingly, one of the witnesses admitted his affidavit of execution was not correct. There was no meeting on the 3rd of May, and as a result, costs were ordered against Ebrahimi. So again, normally out of lockdown, a will would be signed at a solicitor's office, and there would be no question about it being signed incorrectly. There would always be 2 independent witnesses available who would complete the attestation. But because of lockdown, that hasn't been possible. And I think those are, or there could well be, homemade wills or wills signed at home, which really ought to be checked. So moving to the next slide. And this is an example really of unintended inheritance tax consequences where unexpected deaths have occurred. And again, this may well have occurred during lockdown with COVID. So in this particular case, it involved Tom Makin, who is heir or was heir to the JD Sports empire. And sadly, he died in 2019, having bone cancer. Prior to that, and prior to his marriage, he made a gift, a half share in the family home to his then girlfriend, and that was made in 2017. They then married in 2018, but because the gift was made before marriage, there was no spouse exemption at the time. And because he died within the 7 years of the gift being made, it meant it was taxable. And as a result, his estate has suffered a inheritance tax bill that would have been unexpected of 300,000. And despite everybody concerned agreeing that's not what was intended, nevertheless, the executors, with the consent of the wife and parents, have had to apply for an order from the High Court on the basis that the gift be officially declared a mistake. And so again, sadly, because advice hadn't been taken, perhaps he hadn't intended to get married in 2017, but if he'd taken advice, nevertheless, he could have considered life insurance written in trust for the 7-year period before that gift fell out of his estate for inheritance tax purposes. And at least that would have been some, well, at least a more cost-effective means of addressing the problem. So moving on to the next slide. And here we are, we've got a situation now where circumstances will have changed. And so one area that definitely needs to be reviewed for clients when making provision in wills will be whether their adult children will have sufficient financial provision, and indeed their spouses for that matter. But really, claims for reasonable financial provision are going to be on the increase. People are relying more on inheritances now than ever before to fund their retirement. And there have been, well, there are statistics there that people born in the 1980s can expect twice as much of their lifetime income to come from inheritance compared to those born in the 1960s. And so really, when taking will instructions, it's again, there is an onus on the will drafter to raise the question of reasonable financial provision. And one area that is really much more commonly used now to address that is a flexible will. So a flexible will is one that provides that the estate, or the main part of the estate, the residue, is held on a discretionary trust, and the class of beneficiaries could include everybody that potentially the will writer would like to benefit. So that could be spouse, children, remoter descendants such as grandchildren, even husbands and wives of children and grandchildren, possibly charities. But the class can be wide, and then as circumstances change, the letter of wishes, which is prepared in conjunction with the will for the trustees to have regard to, can also be change to reflect those new circumstances. And so if one child has particularly fallen on hard times, that can be added to the letter of wishes. Or if not, at least the trustees can have regard to the new circumstances when exercising discretion and making provision. And it's certainly one way of being flexible to adapt to new circumstances post-death, where otherwise it might lead to an application to court for reasonable financial provision. So moving on to the next slide. And here we have post-death arrangements. So this is really a very popular area and a very busy area actually of work for us at the moment. And this is really looking at a combination of post-death inheritance tax planning using deeds of variation, and also ensuring reasonable financial provision is made in an appropriate way, again, where there might have been a change in financial circumstances. It might sound a bit odd, but it is possible to change an inheritance post-death within 2 years. And if completed within 2 years, then the tax effect of that new arrangement is read back to the original date of death. And so, for example, where an adult child might have inherited an estate outright and then actually simply increase their inheritance tax burden, and it might have been an inheritance they didn't need, instead, they could redirect that inheritance to a discretionary trust. There'd be no charges, there's potential charges to inheritance tax when creating lifetime trust, but there would be no charge with this situation because it's read back to the date of death. Indeed, the adult child can still continue to be a beneficiary, and the trust can loan them a sum to reflect their inheritance for them to use for the rest of their lifetime. And when they die, that loan is repaid to the trust and reduces in a tax saving on their estate. Another option is that instead of making provision for them, monies are provided for their children. And quite often, it may be a situation where the children are looking to buy properties to set themselves up in life, and the inheritance will be really useful in terms of deposits for them. And so that's not an uncommon situation at all. So really, in terms of the solution here, it is important that anybody considering a variation consults a solicitor to ensure that firstly it's drafted appropriately, and secondly to consider any potential tax consequences, not just of the arrangement itself, but also of any potential trust that might be appropriate for them going forwards. And the real benefit of this, which I really like actually, is the fact that the beneficiary giving up their inheritance can still receive the benefit from the trust without falling foul of gift with reservation of benefit rules, which sounds a bit odd, but it is entirely possible. So moving on to the next slide. And another issue, sadly, of the whole pandemic has been the volume of work and the impact that has had on the probate process. And unfortunately, the probate registries have been overwhelmed at a time where there have been so many changes in place so that they could get on board with online applications in order to keep functioning. And there's been centralisation, and so that's made it very difficult for members of the public to be able to contact somebody at the probate registry to deal with their inquiries. And so you can see that the deaths associated with COVID as at 27th of April was over 127,000. So the mortality rate has significantly increased. So one solution to this hardship situation where access to funds might be an issue following a bereavement is to think about situations where probate isn't required. And so, for example, life insurance written in trust will be one option. Another situation is to have joint accounts to enable immediate access to money. Obviously, surviving spouses, though, they ought to be ensuring that's all in place. And I did have a client actually who thought it was a good idea to have joint store cards, in particular for her Waitrose account, so that she was still able to use this following her husband's death. So certainly there's a conversation to be had, again, when taking will instructions, to look at the immediate after death scenario and making sure that any survivor in a couple situation has access to money. And so moving on to the next slide. So inheritance tax, and the inheritance tax receipts are increasing. In fact, they've doubled over the last 10 years, or more than doubled. And we're in a situation where that's just going to continue following the spring budget this year, when allowances were frozen. And so we're in a situation where property prices are increasing, but tax allowances aren't increasing at the same rate. And you can see with the statistics there, the nil rate band has been frozen since, well, 12 years now, at 325,000. But the average UK house price has increased 60.7% during that period. And now we have a residence nil rate band allowance, which is also being frozen. Originally, it was supposed to be linked to the consumer price index, but now that's been reneged upon. So the average inheritance tax liability in 2017-18, which is pre-COVID, was 197,000, and that's not an insignificant sum. And so I think going forward, because we know the situation is only going to get worse, it's going to be really important to make sure that any allowances are used, particularly if those are going to be reviewed and perhaps removed by the government in an attempt to raise more tax. So moving to the next slide, we're looking at potentially trying to make sure really that the residence nil rate band, for example, isn't lost. The lifetime allowance, those SIPs are a really efficient way of passing on pensions because they're free of inheritance tax. But again, there are limits now as to how much can be held within a SIP due to the freezing of the lifetime allowance. So other alternatives do need to be looked at. And if we move to the next slide, you'll see that there's still the PETs in place. Those are potentially exempt transfers. In other words, gifts that fall out of a person's estate 7 years after they've been made. And those gifts have no limit currently. There is talk about putting a new limit on that, which would be possibly £30,000. So I think now is a really good opportune moment to review inheritance tax planning and maximise PET's level. Another relief that there have been rumours it might be removed, particularly from investments or shares that might be listed, for example, on AIM, is business relief, formerly business property relief. And trusts have been attacked a number of times by the government in the past. But again, it is a vehicle that can currently be used in conjunction with other reliefs in terms of overall inheritance tax planning. Gifts out of income is a really generous relief currently. If you're in a high income situation, you should be looking to gift anything that's disposable, that's not required for normal expenditure. And then also, we're really lucky to still have post-death planning arrangements. And again, we may not have them for much longer. So now is the time really to keep this under review and to use them or lose them. So then moving to the next slide. So trying to find the positives really coming out of COVID. And I suppose the main positive that we have is the fact that the vaccine rollout has been such a huge success. And also, I suppose one can look at the fact that technology now has been fast-tracked through in the area of wills and powers of attorney as well as probates. And although there have been problems and teething problems, and there still are, in fact, due to the volume of work, really changed and really going forward. And one thing and that's quite a big change, and the fact that perhaps certain formalities required for a valid will should be removed. And so there will be changes in the future, but I think for now it's really important. It's coming out of lockdown. Really been done so far scenarios, and perhaps a flexible will might be the most appropriate solution going forward. But that's the area really that I would be looking at coming out of lockdown over the next few months. Anyway, I hope that's been helpful, and thank you very much for looking and listening. Thank you. Go back to Tara.
Thank you, Kate. Some really useful bits of information there. And we are always happy to answer any questions or deal with any concerns. We don't have time for questions today, but I've put Kate's email address there and contact details if anybody would like to contact us afterwards. As I said at the beginning, this is the first in a series of 3 webinars dealing with the emergence from lockdown. So if you would like to look at the other 2 on lasting powers of attorney and disputes against estates, then please do just look at our website. Thank you very much for joining us today, and that concludes our presentation. Thank you.